This video will introduce you to substituted service via social media. I will firstly explain what substituted service means before discussing two cases where courts have permitted defendants to be served using social media. With respect to the rules of procedure, service is defined as the act of delivering an order upon a party to originate a proceeding. Ordinarily, personal service is required to initiate an action, which is generally effected by leaving a copy of the originating process with the defendant. However, where a plaintiff experiences difficulties in effecting personal service, a party can seek leave of the court for an order for substituted service, which dispenses with the need for the document to be served personally. There are two requirements for substituted service, namely, that personal service must be too difficult or impractical, and that the substituted method proposed must be likely to bring the proceedings to the defendant's attention. It is easy to see how the internet could assist in efficiently serving people who are outside of the country or who cannot be served personally. In particular, there have been some recent cases which have attempted to use social media to effect service on parties to proceedings. This was seen in the landmark case of MKM Capital Proprietary Limited and Corbo and Poyser, where a lender attempted to serve a default judgment via the Facebook accounts of two mortgagees who had defaulted on their mortgage. The service was deemed effective as the mortgagees' names, birth dates, and email addresses corresponded with the Facebook accounts, satisfying the court that the Facebook accounts did belong to and were monitored by the mortgagees. However, substituted service via social media has been treated somewhat cautiously by other Australian courts, as it raises issues regarding the identity of the person served. In Flowrider and Mothership Music Proprietary Limited, the musician Flowrider was paid a $55,000 advance payment for his appearance at a concert in New South Wales. After failing to appear at the concert organisers, Mothership Music, attempted to serve an originating process to Flowrider via his Facebook page, which was linked to the official Flowrider website. As he did not respond to the process, a default judgment was awarded to Mothership Music, which was successfully appealed on the basis that the originating application was not properly served. The appeal was successful because evidence provided did not satisfy the presiding judge that the Facebook page was actually linked to and operated by Flowrider. In summary, substituted service via social media is potentially an efficient new way forward in utilising the internet to serve parties who might otherwise be unreachable. However, those wishing to use this method of service should keep these pointers in mind. Firstly, plaintiffs should be careful to ensure the social media account being served actually belongs to the defendant party. This could be done by providing the judge with background information about the operation of the social media account. In addition, you should ensure that the social media site allows for the website to be a forum of service in their terms and conditions. You also need to consider whether you are breaching privacy laws in effecting service on a public forum. And finally, be mindful that rules for service are different across different legal systems globally. This could nullify your otherwise effective attempt at service via social media. Thank you.